Thank you, Mr. Chairman. Thanks to all members of the panel today, excellent witnesses. Ms. Olson, let me start with you, if I might, and go to the issue of attorney's fees, where this has arisen. That looks like in H.R. 3017, we're going to award attorney fees on the basis of administrative decisions. It seems to me this might simply increase the weight accorded to administrative decisions, might put you, if you were representing a client, at a disadvantage when weighing the risks of proceeding with the defense, and you might be more inclined to recommend a settlement to your employer client. Can you address this issue of how attorney fees are addressed in 3017 for us, please?
Yes, thank you very much. ENDA specifically states that it does not intend to provide different remedies for attorney's fees than those that are available under Title VII. But yet it has a provision that in fact does that, so that ENDA states that the procedures and remedies should be applicable, those that we see in Title VII, but it says that there will be an availability of attorney's fees with respect to somebody who is a prevailing party in an administrative proceeding, and that in connection with that administrative proceeding, the administrative officer, for example, the EEOC with respect to private employers, will have the authority to actually grant those attorney's fees. An administrative proceeding before the EEOC is supposed to be an investigative and conciliatory proceeding. It's a proceeding where the rules of evidence don't apply and where employers and employees share information with the intent to hopefully be able to resolve issues without litigation. With respect to Title VII, with respect to the Americans with Disabilities Act, and with respect to all other federal employment discrimination legislation, there is no right for the EEOC to actually make an award of attorney's fees in connection with any of its administrative proceedings. And in fact, the notice of substantial evidence, if issued by the EEOC, is not reviewable by a court and is not required to be based on any written reasoned decision. Therefore, the due process rights of a prevailing party, if one would be defined as such, in that kind of proceeding would not be present. So I think it would be inappropriate. I'm not sure that's really what was intended. This may be a provision in ENDA that just needs some more work.
Yeah, okay, thank you very much. That's a following up on Chairman Miller's question, and so some suggestions for you might be very useful for the